For more, I want to bring in Neama Rahmani. He's a former federal prosecutor and now the president of West Coast Trial Lawyers. Neama, thank you for joining me. What legal privileges does the Justice Department have in choosing what to redact?
Ike, that's the question here. And it's not just redaction. And Olivia talked about the political process, but really, it's the legal one that matters here. Let's not forget the Justice Department, Attorney General Pam Bondi, with a stroke of her pen, could have released the full Epstein files and waived the privileges that apply here. We're talking about the law enforcement privilege, the deliberative process privilege, and maybe the executive privilege. Now, if they choose to follow the law and disclose the entirety of the Epstein files, there's really only two categories of information that can't be produced. The first is grand jury materials. That has to remain sealed and secret unless a federal judge orders them produced. And the second would be identifying information for victims of sex abuse. That has to be redacted. But other than that, if the DOJ chooses to comply with this law, they have to produce everything. Now, of course, the Department of Justice can choose to assert these privileges, saying that they're still investigating individuals in the Southern District of New York, U.S. Attorney Clayton there, and therefore they're not going to comply, in which case we're setting up a dispute between Article 1, the legislature, Article 2, the executive branch, and an Article 3 judge will have to sort through those privileges. So it'll be interesting to see what the DOJ does, like Olivia says, but let's not forget, this act really wasn't necessary. They could have released these files on their own and waived the applicable privileges.
Right. Now, I want to make sure I get your name right. Neama Rahmani. I messed that up before. All right. Now, President Trump, he's also asking the Justice Department to investigate several high-profile Democrats alleging they had a connection to Epstein. So how could that action impact releasing information?
It could. So if there's an ongoing investigation, we've all heard that. That's where that law enforcement privilege applies, right? So whether it's the media, whether it's Congress, a civil plaintiff, they can't subpoena the Department of Justice to produce its investigative files. But even if an investigation is closed, the deliberative process privilege doesn't require the DOJ to produce these files. That's typically how it works. Now, obviously, we know that the DOJ in July issued a memo saying there's no legal basis to go after any third parties or prosecute them or investigate them as a result of the Epstein abuse. So if they were to investigate the Bill Clintons, Larry Summers, Reid Hoffmans of the world, these are individuals that the president has identified as potentially being associated with Epstein. Well, that would be a 180 for the DOJ as well. Let's not forget Bondi and high-level folks there said there is no Epstein list and there is no basis to go after other individuals. So if Clayton and assistant U.S. attorneys in the Southern District of New York do, that would be an about face for the DOJ.
Now, is there any legal rationale for the Justice Department to choose to not release these files?
I don't think so, especially when Trump ran on this issue. Bondi and Patel, before they were appointed to those positions, said they would release the files. As of earlier this year in February, we thought we would have the complete Epstein files. So I don't understand why the administration is sitting on this. But I also want to raise one very important point. If we're talking about the law, even if the full Epstein files are released and we see the FBI interviews, all the emails, the videos, unless there's a victim who's ready, willing, and able to testify against someone who's alive, obviously can't prosecute a dead person, there's not going to be a criminal prosecution here because under the rules of evidence, what's been produced so far is hearsay. And under the confrontation clause of the Constitution, someone who's accused, a criminal defendant, has the right to cross-examine his accuser. So the emails, they can't be introduced as evidence. Virginia Giuffre's memoir, similarly, can't be introduced as evidence. Those FBI interview notes, the same applies. So unless there's a victim that comes forward, Ike, we're probably not going to see the prosecutions in criminal justice that many people are asking for.
Interesting points. Neama Rahmani, thank you very much for your analysis.